Welcome to another edition Litigation Psychology Podcast, brought to you by Courtroom Sciences. I am Dr. Bill Kanaski. I have to tell you, first announcement, it's very nice to be doing a podcast that's not at 4 a.m. in the morning. I appreciate that. I actually have a day off here to enjoy myself, hit the gym. I have to start with my rant today, and my target is Southwest Airlines. And we have a very special guest. He's actually part of this story because I was working with him a couple weeks ago and just trying to get home to the part 3 of the Duke Carolina finale, which we'll talk about in a second. And I get to Love Field. In fact, my guest and I right out in front of the building, and he went to DFW, I went to Love, and I get to the airport and Southwest cancels my flight and puts me on a 6 a.m. And I'm like, whoa, wait a second. Like, I'm business select, I'm A1. What the hell is going on? Oh, it's weather in Orlando. You can't. I go, well, can you put me on a different airline? Like, I got to get back because this big game's tomorrow. Weather in Orlando, it's terrible. You're not going to be able to fly to Orlando. Well, I go back to my hotel. I'm just irate, pissed. And I call home and I'm like, hey, honey, my flight got canceled. The weather must be bad there. She's like, oh, it's bright and sunny. It's bright and what do you mean it's bright and sunny? I just got told it would. And then, of course, overnight into the next day, all over the national news, Southwest, their computer systems nationally went down. Okay. And they canceled a bunch of flights. Everything came to a standstill. They just lied to my face. I didn't even get a drink coupon out of this. Luckily, I was able to get home, but that was a 4 a.m. wake up again to get to a 6 a.m. flight. Luckily, I was able to take a nap before the huge Duke Carolina finale, and the Carolina Tar Heels prevail and send Coach K packing forever. Every Duke fan can suck on it. Very special guest today from the law firm of Bovis Kyle in Atlanta, Georgia, Billy Davis. Billy, how are you?
I'm great, Bill. Good to see you.
Hey, I read your bio, and I got to tell you, you have an interesting background. So I've got to hear the backstory on that. You were a financial advisor, right? Like one of the least stressful jobs from what I hear, really cushy, right? Right. You're taking people out to dinner and you're just spending their money. This is fantastic. You're investing their money. And then you decide to go into law.
That's right.
Have you seen a doctor, maybe a psychologist over this decision?
There wasn't enough stress in the financial services sector, especially when I was doing that. This is years ago now, but if you remember the .com bubble bursting, that back then we used to talk about the high on the NASDAQ. I think it was like January 15th. I used to have the date memorized, but that was exactly the date that I got licensed to sell securities.
So
it was a tough gig. Yeah.
Timing is everything, right? Well, yeah, you made it into law. Now you're a graduate of Auburn University, correct?
That's right. And LSU for law school.
I have no problems with Auburn. I kind of like Auburn. Now you stole arguably one of our best players named Kessler Walker from North Carolina, who was, I think, all SEC defense this year in basketball. But I think Auburn had a pretty good run, didn't they?
Yeah. And I mean, I think they're not the team they were a few years ago, but we're excited about what's to come.
So you live in Atlanta. So being an Auburn grad, do like people egg your house? Do they like toilet paper what do they do?
So actually, I mean, outside of cities in the state of Alabama, Atlanta is the biggest destination for Auburn grads. So I'm really generally in good company here. There's, of course, Atlanta's huge, but it's a great place to be if you went to an SEC school, and there's really no shortage of Auburn fans here.
Oh, well, there you go. A little melting pot of the Southeastern Conference. So your practice looks pretty diverse, Billy. Tell us about the types of cases that you tend to work on.
Sure. Yeah. So probably the biggest percentage of them tend to be, well, first of all, it's all defense work. And then the largest percentage will involve catastrophic injuries. So transportation litigation, those would be, tractor trailer crashes, things blowing up at refineries, general mayhem, things of that nature. But where you're going to have people who are either killed or seriously injured, or perhaps groups of people who are hurt. And then I do some legal and medical malpractice work, defending doctors, lawyers, nurses, folks in the medical profession.
Sure.
And then the rest of it is just sort of, generic, we would call general liability work. And so that's, there are businesses out there, they have insurance policies for various things. And lo and behold, they get sued for one reason or another. And so I and several people in my firm handle that kind of work. We defend businesses and their employees when they get sued in the ordinary course of business.
Excellent. Now, there's a lot of defense attorneys out there that really pick one of those areas and they become a specialist. You're more diverse. How does that diversity help you as an attorney working on several different types of cases versus, say, just products or just transportation?
I think it helps keep me sharp. And I think, I think the skill set really, and I've said this for years, is litigation. If you got to know how to try a case, you got to know how to set a case up to go to trial. We try so few of them these days. So really aggressive pretrial litigation is sort of the name of the game. But I view the actual work, though, whether it be a legal malpractice case or a transportation case, sort of as an opportunity to cross train. There's a lot of similar themes in those cases. At the end of the day, you have to be sharp on the details of that particular business. But it provides a variety of things for me to do. For example, the legal malpractice cases are perhaps the most interesting because ideally, if you're going to defend a legal malpractice case, you want to be able to demonstrate that there wasn't malpractice. But unfortunately, you can't always do that. And when you can't, then you focus on demonstrating that there really wasn't any damage caused by the malpractice. And so that typically means you're stepping into the shoes of whatever transaction or litigation was going on at the time of the malpractice. And then so if it was a case that was going on and the allegation is that the lawyer screwed up the case, we end up actually retrying that underlying case. And if the jury comes back with a zero, then it means there was no harm, no foul, essentially. So in that kind of work, you really, as a lawyer, I think, are generally jumping into entirely different areas of law from one case to the next. And again, at the end of the day, the skill set is litigating.
So, okay, true or false, and I need brutal honesty here. Lawyers, worst witnesses, right?
Absolutely.
Okay. Really, because you're wired a certain way, right? That has to be tough preparing another lawyer for deposition or trial testimony. Is it because they can't get out of lawyer mode? It's so hard to get in the witness mode?
I think that's it. And I think, Bill, even the example I like to give is, if you know a guy who's a great mechanic, and then you look at his car, it's typically being worked on and it's covered in primer. If you know a guy who's an architect, typically they're working on something in their house and it's never quite done. And so my theory is that, because lawyers are engaged in the practice of lawyering all day long, they when it comes time to their, to actually litigate something they did, it's a mess. Yeah. So.
Yeah, that makes sense. Tell us a little bit about your law firm and kind of how you think, what the firm does to distinguish itself, because there's a lot of law firms in Atlanta and a lot in the Southeast. Tell us about the firm and what you think the best characteristics are.
Sure. Yeah. So, we've got really a diverse number of practice groups. And so, our firm is in some ways easily recognizable as a traditional insurance defense firm. Obviously doing the kind of work that I do, general liability insurance defense. But then we actually have a corporate law section that does a lot of transactional work. They operate as the city attorney for one of the large cities just outside of Atlanta proper in the metro Atlanta area. And they do a lot of transactional work as well. And then we've got a fairly large workers' compensation section that handles workers' compensation defense. We've got a few folks who handle work nationally and operate as outside national counsel for some larger clients in a couple of different areas. And then interestingly, we actually have a family law section that handles high net worth divorces in the metro Atlanta area. So that's not something I think you typically find at your regular insurance defense firm. But I love it because it really allows us to be full service because our clients, occasionally need divorce and family law services, and we can do it all in one shop.
Yeah, that makes sense. So we recently worked together, and we had never worked together before, and we have not talked before this podcast. We have not rehearsed any of this, and you and some other attorneys and your client. We met in Texas, and we did 2 days of corporate rep witness training prior to deposition. And you've been through witness prep sessions before, obviously, but probably not with somebody like me. Share with our audience, because I think this is important, because I think that those sessions went really well and we learned a lot. Things that maybe surprised you about the approach I take, and maybe some of the things that were even shocking to you relative to, say, a standard witness prep just with attorney and client.
Sure. I think the number one surprise really was, we really brought several different folks from the company with an eye toward, knowing that everybody who works at a company, when they get hired for their particular skill set. They're good managers, or they're good truck drivers, or whatever the case may be. They're never hired because they're a good witness.
True.
And so, so knowing that after doing this for years, some people just have that sort of, je ne sais quoi, and they're just a good witness for whatever reason. So we had several folks there, and what was the biggest surprise was to find out that our ultimate selection of the person we felt was probably in the best position to testify was not, I think, who everybody would have assumed it would have been at the outset of it. And so it was a very pleasant surprise, though, because by the end of the 2 days, I think everyone in the room felt very comfortable with that decision. And really, as the lawyer involved, I was particularly pleasantly surprised by that, because it made me realize if we had just gone off of our gut instinct, we wouldn't have bet on the right horse, I don't think. So that was a great revelation.
Yeah, and we do that a lot because there's a lot of, like, if you rely on a gut feeling, that can lead to trouble, right? And so it's a good way to make sure you have the right person in the chair is by putting them through the training, making them perform. There are a couple of different parts of the training that I want you to comment on. There's particularly 2 parts that this witness struggled with. Number one, the speed of the interaction. This witness was answering questions, and our other attorney couldn't get in the objections. Can you tell us about your experience with the training, how a slow witness is a much better and safer witness versus a witness that responds more spontaneously?
Sure. I think everyone who litigates, every lawyer who litigates, always wishes their witness would answer questions more slowly. But I frankly think a lot of us just give up on that. I mean, it's I think part of standard deposition training, but it's very difficult to find someone who will do it and who can maintain it consistently. And so I was really pleased. I think so. Of course, our training for the 2 days together was split up. First day was mostly theory. Which I thought was very important, because I think the witness is understanding the why behind what we do, and also having had an opportunity to see some actual clips of depositions to understand how it goes wrong and what it looks like when it goes wrong. I think that left them really well prepared for the second day, which was all practical. And I think the first day training, and I've spoken with the witness that we selected as a result of that process, and he's told me it really did shine a light on some things for him that he kind of keeps in the back of his mind now as he's testifying. And he did a fantastic job, and I know he's going to do a fantastic job when he testifies at slowing down and listening to those questions, because as you taught us, Bill, you cannot listen and formulate an answer at the same time.
Can't do it.
It needs to be a multi-step process. You need to listen and then think, and then give your answer. And of course, there's so many other practical reasons why that's a good idea. It gives the lawyer time to object. And as you also taught us, it gives the witness control over the deposition. Mm-hmm. That's probably the only thing the witness has control over, is the speed and pacing. And we've all seen it go bad. I mean, shoot, even on television, it's one of the things. It's dramatic, right? It's one of the things they play out in a courtroom or lawyer scene. The lawyer is on a tear asking questions, one right after the other, and it's exciting to watch on a television show. It's horrifying to watch if you're defending that witness.
Yeah.
So.
No, no, absolutely. What we try and want to do is, maximize cognition to get the most effective answer. The problem is in society, and particularly these people and their roles at work, time is money. Speed and efficiency are an important part of communication at work. And then you do that in the depth, and the skills that make you great at work make you a terrible witness. So that's why that speed's so important. But it's a learned skill. It's really, really a learned skill that requires practice and feedback. Now, the other thing that happened, now this particular witness wasn't a big talker, wasn't given long, wordy answers, which is a problem we see with a lot of witnesses. He didn't have that problem. He was actually good at keeping it tight. But do you recall the level of emotion and how that emotion came out in his body language, and how quickly he kind of took the emotional bait from an aggressive questioner?
Sure. And, I think the toughest thing, if I have to put myself into a potential witness's shoes, especially if they're going to provide corporate testimony. So they're already walking into the room for prep under pressure because they understand they've been asked by upper management to do this. And so there's a real feeling all eyes are on me. And then obviously from their perspective, especially if they've never done this before, they believe that they're there to be the company's spokesperson in the way that they've come to understand what the company's message is. And so, with the messages on the website, with the messages internally about a lot of policies and procedures. And of course, in this particular case, we were dealing with a transportation issue. And so that's going to involve, internal rules and regulations regarding safety. And of course, anybody who's in this business and handles transportation work and especially work where safety rules are at issue, it's just become a real quagmire, a real tough deal for witnesses. And so I think this poor witness, and again, he's a great employee. Yep. He does his job extremely well.
Yep.
But we're asking him to come in as a witness and tone down a lot of the corporate speak that he would normally get fired if he didn't say. And so I think all that pressure, it certainly was not his fault that he got emotionally activated, because he's a company cheerleader. In any other context, that's the guy you want speaking on behalf of the company. But this is litigation. This is a deposition. It's a whole different ball of wax. And so again, I thought that was particularly helpful to see. I'm glad we had that reaction in a test setting,
exactly,
rather than when it was live.
It's a lot cheaper in the test setting than it is in the reals. And as you have those emotional reactions, what we would call that amygdala hijack, hippocampal circuit reacting. That's a neurochemical response that lasts 3 to 5 hours. It's really hard to get it back together once you've become emotional. So that's a really tricky topic. Then the other thing that came up, which does come up at times, not a lot, but I found it to be interesting, and I want your thoughts on this and see how often you see this, is, and I think we found this on day one actually, was this, your role as the witness, particularly as the corporate rep. There was some very unexpected fear that if I'm not perfect in this depth, I'm losing my job, I'm getting demoted. Do you see that a lot? I see it sometimes, but let's put it this way. It was the type of fear that we literally had to take a couple timeouts and people needed to go for walks and talk, because that's how troubling it was. I'm glad we found that, because if that would have popped up in the middle of deposition, we would have been screwed.
Sure. Yeah. Again, and so glad that we went through the process, as you just said, in order to uncover that. And I don't think it's the witness's fault at all. This is, as you know, Bill, I think sometimes something I tell my clients all the time is that it's a little bit like going through the looking glass when you step out of whatever you were doing normally, and all of a sudden you're in litigation land. And I try and remain pretty sensitive to that as a practitioner, because most folks, are not professional witnesses, so they're giving a deposition for the first time or only for the second time. And so I try and keep in mind the pressure on them and what's going on. But I think in this case, I've seen that happen before, actually. And I think it's just where you have a real strong corporate culture around a particular issue. And it just so happens that that particular issue is also going to be problematic in the litigation. And so you're having someone who's used to cheerleading that issue, and then now we're asking them to take a little bit of a step back from it and maybe just deliver that issue in a more neutral fashion, which is the smart thing to do in litigation. But it runs very contrary to their programming, I think, in their brain. And I think certainly there's a lot of fear of, well, if my boss reads this transcript and I'm not cheerleading the typical company line, I'm going to lose my job. What you guys are asking me to do is going to get me into trouble. So interesting and well understood reaction.
Yeah, absolutely. Can you comment on the importance? Because one thing that I see the defense bar persistently getting burned on, and I'm not saying it's the attorney's fault. Oftentimes it's the client's fault or the insurance company's fault for not approving various things. The benefits of being proactive and doing things like this early in the process. Because can you imagine, we did that on a Thursday and Friday. If that dep's on Monday, we're in big trouble. Whereas if you have time and you find a problem, you can actually do something about it. What's been your experience as far as how you handle litigation timelines? And I'm assuming, because I feel very strongly about this, earlier the better, right?
Sure, absolutely. I think any lawyer who's been litigating for any amount of time has unfortunately had the experience at least once, but probably several times, where a witness just goes completely off the reservation. The worst, and I won't go into details because I hate war stories, but I actually had that happen to me once at trial. My client was called on cross as the first witness in the trial, and testified so poorly that that the judge actually called for a break 20 minutes into the questioning, which was astonishing. It was right at the beginning of the trial. So,
TV timeout.
It was right. It was pretty tough to sit there and poker face it. But looking back on that, I think in that case, I had recommended that we do some sort of organized witness preparation because from getting burned earlier in my career, I think it's important to have somebody evaluate the witness psychologically, and understand how he's going to respond to pressure. And I just, I think I'm pretty darn good at taking depositions and organizing depositions and defending depositions, but that doesn't necessarily make me, good at evaluating witness psychologically. It's not what I do. It's not my educational background. And I wonder, if we had done that earlier with this witness, if we would have known, once the pressure gets to a certain level, he's just going to forget everything and just start saying yes to whatever they want him to say yes to.
Yeah, and that's what happens. That's exactly what happens. So early intervention is better intervention.
Sure. Well, in that case, I can tell you there was an offer on the table, so settlement was still being discussed even though trial had begun. And after that testimony, when we took a break, the lawyers told me deal's off the table, and now it's And
why would you take the money after that testimony? You just doubled or tripled your money. I mean, wow, that's amazing. What have you and by the way, you are in the birthplace of the plaintiff reptile theory right there in Atlanta. Right. What types of changes have you seen from the plaintiff's bar kind of since things have been picking up lately over here in the last year? Some of the things, I have seen, which kind of it started before, but now it's, they all talk to each other and they all share information. I've seen a lot of aggression by the plaintiff's bar. I've seen a lot of ridiculous demands, and just really not really trying to resolve the case, but just to try to cause a lot of conflict on the defense side. What have you been seeing from the plaintiff's bar?
Well, certainly a lot of aggression.
Yeah.
The way I refer to it is I think, and it depends on the kind of case you're talking about, because it's funny. There's some areas of law where the practitioners are all very professional and they're a pleasure to deal with, but then there's other areas like transportation, where I would say it's very much like a contact sport.
Oh yeah, it is. It is.
Yeah, and I, I'm fortunate. I actually cut my teeth as a litigator doing Jones Act litigation in New Orleans. And I had worked in the oil field as a roughneck. That's how I put myself through college. So I got involved with that kind of early on the defense side. And that litigation, I'm sure you've seen, oil field litigation is its own thing.
I've done several cases down in Louisiana for BP, Chevron. Yeah.
Sure. Yeah. So, and everybody I think has seen the famous Joe Jamail deposition on YouTube and stuff, and so it, I was glad that I had that experience because it does teach you how to handle aggression. And I was reminded of it when we did the preparation with you, Bill, because everything you talked about in terms of the witness not getting activated and controlling their emotions, I think applies equally to the lawyer as well, because when things get aggressive and other lawyers start making it personal, getting in your face, doing things you really think are unprofessional to your witness and not making you happy, you have to keep calm because you need to be objective and make the right decisions. So aggression's a big thing. We've seen I've seen this happen a couple of times now, which I thought was interesting, but asking, sort of creating exhibits in the middle of a deposition, actually asking a witness to sign things in depositions.
Crazy.
And then, there's really not a lot of developed law on that. And so I think there's a lot of fighting going on about how it's all going to shake out, but it can be really, if you're not ready for that, it can catch you off guard for sure. So that's mostly what I've seen. And then you asked me about demands. I mean, that's, Bill, I mean, it's troublesome, I think, these days to give a fair evaluation of a case, a serious injury case, particularly if it's in a hotbed area of litigation like premises liability, negligent security or transportation. Because there's the conventional way that we used to evaluate those. It was sort of a damages driven analysis. What are the medical specials? And we take a look at the jurisdiction, we come up with a number. And I think 5-10 years ago, if you surveyed 10 lawyers, you'd probably come up with an agreeable range across all 10 lawyers, but now I think it largely depends on who has the case, how good is the other lawyer, what is their track record. I don't think you can evaluate it in the conventional damages driven analysis anymore. I think you really need to look more closely on what are the verdicts, regardless of what the injury was. Because juries are just, they're really letting it rip. And
yes, they are.
I'm concerned it's going to be worse now as we come back from COVID. I mean, there's just not enough data post COVID on what juries are doing. Yeah. So
no, we're trying to keep our fingers on the pulse on that one. Billy, have you had the experience of when you're working up a case against, let's just say a reasonable plaintiff attorney, and then one of these aggressive big shots comes into the case late? How do you deal with that? Because I've seen this a lot. This is another thing I've seen where, somebody's got the case for 3 years and then Don Keenan shows up or Lloyd Bell and you're going, holy shit. Right. How do you adjust to that? Because obviously once they come in, they start handling things really, really different. And usually I've seen this become very unreasonable and threatening.
Sure. And look, they are unreasonable, they are threatening, and they're also outstanding lawyers, right, who do great work. I do not disagree. Yeah. And so, my advice, and look, I've been burned on that issue before. Yeah. I mean, we had a case that was we were workshopping it routinely, and we really kind of thought, this lawyer just isn't working it up. We're running across some deadlines here. Maybe we're going to sort of sneak out the back door on this one. And lo and behold, right there at the tail end, they brought a real mighty lawyer in. And look, I got to give it to him. He did a fantastic job in a short period of time. He must not have slept for a few nights in order to get that up to speed that quickly. Wow. But you're right. I think that's an issue that's happening more and more. And so I think that really means we need to be a lot more proactive about getting cases settled and not letting them sit on the books.
I totally agree. All right, last question, then we're going to wrap it up here. And Billy, this has been a great conversation. I think this is a really important question because it scares the hell out of me based on what I've seen, particularly over, I'd say, the last 6 or 7 years. Defense firms, and I've heard this from a million people, guys like you, have told me, I can't keep my good associates. These folks are bouncing around from law firm to law firm. They're millennials. They don't want to work past 5 o'clock. And I've seen a lot of disconnect and the inability to take that associate to the senior to get them up, because you need help. You need these folks to, from a career development standpoint. I think that's really important. I've seen a lot of impatience, I think, from the younger attorneys. What advice would you give that attorney that's maybe in like years 3 to 5 as far as career development, what they need to do to get to that next level and be successful like you?
Well, I think first of all, they're in a great position because they can pretty much go anywhere they want. So that's good, because I think my advice would be to take a look around, and if you're not being given the opportunities that you want, then you need to go put yourself in a position where you're going to work for somebody who's going to give you opportunity. Go find a busy lawyer who's got too much to do. Because I think the story of most lawyers' careers are, they were given a little bit of work to do, and then they just started doing a lot more, and they just kind of took it on their own shoulders, and before they knew it, their phone rings and they've got a brand new client. So that's what I would advise. And I'd also say you got to find somebody who's willing to teach you their business and bring you along. If we all get old and then we complain about what the kids are doing.
I'm already doing that.
Yeah. And I don't really buy it. I mean, I don't, every generation is different. Every generation has a different focus of what they care about. But I refuse to believe that the millennials or Gen Z don't have long-term plans for their lives. I mean, I still think they want to have a pretty house and a family and a life. And they obviously need a career in order to make that happen. Yeah. So I think if I were advising a young lawyer, find somebody who take an interest in you and teach you the business, because there are a lot of us out there who care and want to develop young lawyers.
That's awesome. Billy Davis, thank you so much for being on the podcast. Hopefully we're going to be working again soon, and I would love to have you back, particularly if we have maybe a panel with a couple of other people, to have you back on the show soon.
I'd love to do it. It's good seeing you, Bill.
Okay, and to our audience, thank you so much for participating in another edition of the Litigation Psychology Podcast. This is Dr. Bill Kanaski signing out.